Good morning, everyone. It is Friday, March 18th, 2022. These are the detention hearings for the 323rd Judicial District Court of the State of Texas, Tarrant County's assigned juvenile court. The purpose of today's hearings is not a trial. Instead, the purpose of today's hearings is to determine whether or not probable cause exists to believe that the child may have engaged in delinquent conduct. In making that determination, the law allows me to consider hearsay evidence in the form of a police report forwarded to me by the Juvenile Probation Department. If I find that probable cause exists, I will thereafter proceed to a secondary determination of whether or not the child should be ordered to remain in detention or be released to a parent or guardian. In keeping with the spirit of the open courts provision of the Texas Constitution, these hearings are being broadcast live on YouTube. Recording or rebroadcasting all or part of these hearings is expressly forbidden. Violation of the court's order may subject you to civil and/or criminal contempt proceedings. These hearings are being offered to the participants by Zoom as a convenience. However, these are court proceedings, and you're expected to behave as if you were actually physically in my courtroom. Interruptions will not be accepted or tolerated, and you will be subject to removal without further warning and ordered to appear in person for all future hearings. Unless you are an officer of the court, you're expected to have your camera turned on and your microphone muted until such time as the relevant case is called. Also, all participants are expected to have their backgrounds free from distraction and not be in moving vehicles, etc. Again, please keep your cameras still. If you cannot abide by these basic rules, you will be removed without further warning. We have 13 cases on the docket, 9 of which will be broadcast. First on our docket is DeCavion.
Yes, sir.
DeCavion, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and I have not seen your attorney, Brian Bolton, here this morning, so I'm going to ask Brian Newman, another attorney who regularly represents kids in our court, to step in on Mr. Bolton's behalf. DeCavion, you're here on an aggravated assault with a deadly weapon charge. The court has previously found that probable cause exists to believe that you've engaged in delinquent conduct sufficient to warrant your initial detention. You have a determinate sentence hearing in front of Judge Kim next week. You've been level 1-0 since the 12th, but as you probably know, on an aggravated gun charge, 6 days at level 1-0 is not enough yet to convince me that if I were to release you, you would not be a danger to the community. We take gun cases very seriously here, and those kinds of cases just take longer at level 1-0. Consistent demonstrated behavior of ability to follow the rules before we feel safe releasing you. And so I'm not going to authorize your release at this time. That will be the order of the court. Thank you, DeCavion. Alan.
Good morning, George.
Good morning, Mrs. Wehe. How are you?
I'm good. How are you?
Okay. Are you Alan?
Yes, sir.
Alan, we know each other. My name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Ms. Uzuwiti, is here. Alan, you've been level 1 outstanding for the last six and a half days. You're currently on probation, and you've got a hearing scheduled in front of, I believe, in front of me next week, maybe on Monday. Alan, normally I would be considering you for release right now, but because you're already on probation, it just takes a little bit longer than 6 days. Let's see how your hearing goes on Monday, okay?
Okay.
All right. Thank you, Mrs. Wehe.
Thank you, Anna. We'll see you on Monday, George.
All right. Thank you, Rita. Okay. Callie.
Yes. Yes,
Are
sir.
you Callie?
Yes, sir.
Callie, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And I thought I saw, I did not know. Mr. Houston, could not be here today. I thought he was here earlier. So I'm going to ask Brian Newman, another attorney who regularly represents kids in our court, to step in for Mr. Houston. Callie, I'll make this easy. The court has previously found that probable cause exists to believe that you may have engaged in delinquent conduct sufficient to warrant your initial detention. You're level 3 confined. I'm not going to consider you for release. I'm going to order that you continue to be detained. Thank you, young lady. Demarian.
Yes, sir.
Are you Demarian?
Yes, sir.
Demarian, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And your attorney, Brian Willett, is here. Good morning, Mr. Willett. How are you?
Morning, Judge.
All right, Demarian, the court has previously found that probable cause exists to believe that you may have engaged in delinquent conduct. You've been level 1-0 for the last 7 days. However, you're here on 2 counts of aggravated robbery. Okay. Yeah, seven days, Demarian, at level 1-0. Not quite yet enough to convince me. Let's see. Mr. Morris, have you read the detention hearing report?
Yes, Your Honor.
The bottom half of page 2, your office might want to step on the gas on that because he's got a hearing scheduled in front of me on April 6th. If y'all come in asking for a reset based on the bottom half of page 2 of the detention hearing report on the 6th, I'm going to be inclined to say no and force you to go on the petition that you've got.
Yes, Your Honor. I'll let Mr. Wynn know.
So let's step on the gas. If y'all plan on doing something on that, let's get it done so we can wrap everything up on the 6th. Demarian's been back in detention for 141 days.
Yes, Your Honor.
I think it's time that the state either be put to its burden of proof or there be a plea agreement and we let Demarian progress on. All right, that'll be the order of the court. Thank you.
Thank you. Thank you, Your Honor.
Preston. Are you Preston?
Yeah, that's me.
Pardon?
That's me, sir.
Thank you, sir. Preston, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Julie Jacobson, is here. Good morning, Ms. Jacobson. How are you?
Good morning, Your Honor. How are you?
Better than I deserve. All right. Preston, you've been level 1-0 almost a month. However, the last court setting on the 16th, you failed to appear. And when you fail to show up for court when you're supposed to, it makes me wonder that if I release you again, you wouldn't show up for court the next time. You've got another court setting coming up in a couple of weeks. And so out of abundance of caution to make sure you show up for court when you are supposed to, I'm going to keep you here for now. However, the fact that you're level 1-0 and you've maintained level 1-0 for so long is a circumstance I will take into consideration at your hearing. Okay, so you want to keep that. All right, thank you, sir. Thank you, Ms. Jacobson. Ashton. Are you Ashton?
Yes, sir.
Ashton, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge. Well, actually, this is not your initial detention. this is your initial detention. The purpose of this hearing is not a trial. Instead, the purpose of this hearing is to determine whether or not probable cause exists to believe that you may have engaged in delinquent conduct. In making that determination, the law allows me to consider hearsay evidence in the form of a police report forwarded to me by the Juvenile Probation Department. If I find that probable cause exists, I will thereafter proceed to a secondary determination of whether or not you should be ordered to remain in detention or be released to a parent or guardian. At this hearing, you have the right to remain silent. You also have the right to an attorney, and your attorney, Edwin Youngblood, is here. Good morning, Mr. Youngblood. How are you?
Morning, Judge. I'm fine. And you?
Doing well. Thank you, sir. According to the... Wait a minute. This is not the... Yeah, we're off. Okay. Give me just a second, Ashton. Would you look at that previous packet and see if it's attached to the previous packet? Yeah. There we go. Give me just a second, Ashton. Sorry. Paperwork was a little out of order. Okay. Ashton, according to the police report, back on November 22nd of 2021, 17-year-old Ashton was referred out of custody by the Mansfield ISD Police Department for the offense of theft of property valued at greater than $2,500 but less than $30,000. According to the police report, on the 5th of November at approximately 2:30 in the afternoon, officers assigned to a specific high school were contacted by the front reception desk and asked to go to bus number 356. The complainant stated that suspects, including you and 2 other kids, took, without the victim's permission, $10,000 in U.S. currency that had been in the complainant's possession. All suspects were identified as students at a high school. The complainant stated he removed $10,000 in $100 increments without his mother's permission from their residence. The complainant took the currency to school and informed several unknown suspects that he was in possession of the currency. At approximately 2 o'clock in the afternoon, the complainant walked out of his classroom and went to the boys' second-floor restroom. On his way to the restroom, suspects followed the complainant into the restroom. One of your companions, Ashton, asked the complainant if he could see the currency and take a photo with it. The complainant agreed and removed all of the currency from his pocket and gave the currency to the correspondent to take a photo. While holding the currency and fanning out the $100 bills, that correspondent dropped the currency on the floor. Sometime before that moment, a third correspondent had entered the restroom and also observed the currency on the floor. The suspects and the complainant tried to pick up the currency on the floor. All suspects then walked out of the restroom with the complainant following behind. The complainant stated that he followed you, Ashton, out of the restroom and asked for the money back, but you refused to give the money back and walked off. Officers contacted the complainant's mother, who stated the complainant did not have permission to remove the $10,000 of currency from her home. The complainant's mother filed a report with the Grand Prairie Police Department. Officers recovered $500 and $100 bills from one of the correspondents and released the money to the complainant's sister. Then, shortly before 10 o'clock that same evening, one of the officers went to the listed home for you, Ashton. You refused to let your mother come to the door. You stated that you did not have the money, and you refused to talk with the officers. Officers contacted your mother anyway on the phone and advised her to contact the Grand Prairie Police Department regarding the theft. Officers observed video footage revealing the complainant attempting to stop you, Ashton, from leaving the boys' restroom with the money in your hand, and observed you push the complainant out of the way. At one point, you can be seen fanning out the money and then counting the money on the school cameras while the complainant was beside you asking for the money back. Officers also observed the complainant attempting to keep Ashton from exiting the school, then observed them both exit the building. The complainant estimates you had about $9,000 in your possession, Ashton. On the 10th of November, one of the officers spoke with one of your co-respondents regarding the incident, and that co-respondent verbally told the officers he was present in the restroom and that you, Ashton, were the person that had all of the currency. On the 1st of March, you were brought to JPD from the Tarrant County Jail, and you received 2 years deferred for an adult case. All right, I'm going to find that probable cause exists to believe that you may have engaged in delinquent conduct. Mr. Youngblood, your thoughts?
I understand sadly that he's now on level 3, had been doing better.
You are correct, Mr. Youngblood. Ashton, unless you are level 1-0, I cannot consider you for release. And so on that basis, I must order that you continue to be detained. We will continue to watch your behavior while you're in the back, and Judge Kim will ultimately take that into account. Thank you, sir.
I got a question. So I thought I had court on the 22nd. What was this date like?
This was a detention hearing.
But I just had one I just had one Wednesday.
Yes, sir, he did. That his parent wasn't there, and Mr. Nava gave me information. I used the information to call his parent, and I had thought that his parent would show up. At that time, he was level 1, and the court was inclined to let him go if parent appeared, and that's why it was rescheduled.
Does that answer your question, Ashton?
Yes, sir. So I got court on the 22nd again, right?
Let me double check. The court coordinator is telling me it is scheduled for April 1st.
All right.
All right, thank you, sir.
May I be excused, Your Honor?
Yes, sir. Thank you, Mr. Youngblood.
Yes, sir. Have a good weekend.
You as well. All right, are you Kaylee?
Yes, sir.
Kaylee, my name is Judge Porter. The law says when you're brought into detention, you must see a judge within 2 business days. The purpose of this hearing is not a trial. Instead, the purpose of today's hearing is to determine whether or not probable cause exists to believe that you may have engaged in delinquent conduct. In making that determination, the law allows me to consider hearsay evidence in the form of a police report forwarded to me by the Juvenile Probation Department. If I find that probable cause exists, I will thereafter proceed to a secondary determination of whether or not you should be ordered to remain in detention or be released to a parent or guardian. At this hearing, you have the right to remain silent. You also have the right to an attorney, and your attorney, Brian Newman, is here. Good morning, Mr. Newman. How are you?
Morning, Judge. Doing fine.
All right. Kaylee, according to the police report, let's see, 2 days ago, you were referred in custody by the Fort Worth Police Department for the offense of assault causing bodily injury with family violence. According to the police report, officers were dispatched to your home on a domestic disturbance call. Your mom reported that she attempted to take your cell phone away as a form of punishment. Mom reported that you got upset and kicked Mom in the stomach multiple times, causing pain. Mom also reported that you struck her in the upper chest area, causing pain, and officers observed a visible bruise. You were then detained and transported to JPD. All right, I will find that probable cause exists to believe that you may have engaged in delinquent conduct sufficient to warrant your initial detention. Are you Mom and Dad?
Yes.
Okay, what's going on with Kaylee as far as the violence between Mom and Kaylee?
I think it was just that he didn't get his way and got mad, and we give him a lot of leeway. There are consequences, not punishments, and the consequence was something that made him feel uncomfortable, and he got mad.
Do you think this kind of behavior is going to continue going forward?
I'm not sure. That is up to Kaylee. However, the plan is to have them go straight from here, if they're released today, to UBH, and that will be addressed. So that's where we're at right now.
All right. You know Kaylee better than anybody else. Do you feel safe for me to release Kaylee to you, and then for you as the parent to direct any necessary treatment or doctor's appointments and things like that going forward?
Yes, because Kaylee's going directly to an inpatient program after this. I do feel comfortable with Kaylee being released today. If Kaylee was to come home, I would not feel comfortable, but we have something set up.
Mr. Kroll, am I correct? Kaylee has no prior referrals to the department?
You are correct, Your Honor.
All right. Based on the absence of any prior history of referrals to the department, based on the parent's plan of a specific course of action to treat what seems to be the child's needs, I'm going to authorize Kaylee's release to the parents today. Kaylee, I hope this was a wake-up call. If it wasn't, Mom and Dad, feel free to get in touch with Mr. Kroll, and we can have an out-of-custody detention hearing, at which time I can consider whether or not Kaylee is a sufficient danger to either y'all or to Kaylee, sufficient to warrant Kaylee's being ordered into detention. So know that possibility is there. Hopefully Kaylee will be receptive to your direction, Mom and Dad. All right, that'll be the order of the court. Thank you.
Thank you, sir.
Thank you, sir.
Thank you, Your Honor.
Caesar. All right, are you Caesar?
Yes, Your Honor.
Caesar, my name is Judge Porter. The law says when you're brought into detention, you must see a judge within 2 business days. You have the right to remain silent. You also have the right to an attorney. And your attorney, Larry Beaver, could not be here today. He actually left for vacation yesterday, but I'm going to ask Brian Newman, another attorney who regularly represents kids in our court, to step in for Mr. Beaver. Good morning, Mr. Newman. How are you?
Good morning, Judge. Doing fine. How about yourself?
Better than I deserve. All right, Caesar, you have the right to remain silent. The purpose of this hearing, as you know, it's not a trial. It's a detention hearing to determine if probable cause exists to believe that you may have engaged in delinquent conduct. Judge Terry put you on probation, or wait, no, I was the one. I thought I recognized you. I was the one who put you on probation last fall. You got a modification hearing coming up with Judge Terry, though. So yesterday, around 1:30 in the afternoon, we got a master tamper alert for you allegedly cutting off your EM. We issued the DTA, and you returned home later and was picked up at your home and brought to Kimbo without incident. All right. Well, Caesar, if you want to cut off your monitor, that means I can't trust you. If I don't know where you are, that means you may be getting into trouble somewhere. Worst case scenario, you're walking down the road, you don't have your monitor on, there's a drive-by, somebody shoots you, you're lying in a ditch somewhere, we can't find you, parents don't know where you are. I can't have that on my conscience. That was your decision to cut off your monitor. See, if you hadn't cut off your monitor, at least we would have known where you were. Let's see. I thought I saw Ms. Zamora earlier.
Yes, Your Honor, I'm here.
There you are. Was he drug tested when he came in?
Yes, he was, Your Honor.
What were the results?
Positive for marijuana.
Oh, now we know where he went. Does he have a parent or guardian here today?
No, Your Honor, they couldn't make it and they were having technical issues.
Okay. Well, Caesar, you're destroying government property by cutting off your monitor, going out and getting the devil's lettuce. I can't trust you. So I'm going to keep you here. We'll see how long it takes for you to regain my trust, but I imagine it'll be a little while. Thank you, sir. Thank you, Ms. Zamora. Thank you, Mr. Newman.
Thank you, Judge.
Thank you, Your Honor.
Michaela,
Sir.
my name is Judge Porter. The law says when you're brought into detention, you must see a judge within 2 business days. The purpose of this hearing is not a trial. Instead, the purpose of this hearing is to determine whether or not probable cause exists to believe that you may have engaged in delinquent conduct. In making that determination, the law allows me to consider hearsay evidence in the form of a police report forwarded to me by the Juvenile Probation Department. If I find that probable cause exists, I will thereafter proceed to a secondary determination of whether or not you should be ordered to remain in detention or be released to a parent or guardian. At this hearing, you have the right to remain silent. You also have the right to an attorney, and your attorney, Candace Taylor, could not be here today, but I'm going to ask another attorney, Brian Newman, who regularly represents kids in our court, to fill in for Ms. Taylor at this hearing. Good morning, Mr. Newman. How are you?
Morning, Judge. Doing okay.
All right. Michaela, according to the police report, Thursday of last week, you had an argument with your mother, your probation officer, and your reach therapist both visited with you, and shortly after the therapist left, then you left home without the permission. You later called your therapist, stating that you didn't feel safe at home and you didn't know where to go. The therapist and the probation officer asked you to go to a nearby youth shelter, and on Monday, your probation officer confirmed that you were not at the shelter to which you were directed. Mother was able to track your location to a home in South Fort Worth and contacted law enforcement to let them know where you were at and that you had an active DTA. Fort Worth PD was able to make contact with you, and you were taken into custody without incident. You're currently on probation. Wait, no, you're not. She's no longer on probation. Is that correct? Is Miss Elise? Yes, Miss Elise. She's off probation now.
No, she's still on probation. Her probation ends next month.
Oh, okay. Okay. Does she have a parent or guardian here today?
She does not, sir.
Okay. Michaela, I'm going to keep you here for right now, just because I want to know where you are and I want to know you're safe, and we can keep you safe here. Miss Elise and your mom are working on a plan to find you respite care. And so once they get that plan in place, then we'll take that up. Does that make sense?
Yes, sir.
Okay. You okay with that?
Yes, sir.
Sounds like a good plan?
Yes, sir.
All right. All right. Then that's what we'll do. Miss Elise, continue to work with Mom and keep Michaela updated on that progress, if you would. Thank you, everybody. Thank you, Mr. Newman.
Thank you, Judge.
Thank you.
All right. These hearings have been broadcast live on YouTube in keeping with the spirit of the open courts provision of the Texas Constitution. However, Section 5408, subsection C of the Texas Family Code provides that when a child or children are under the age of 14, the court may close the hearings if the court finds that the child's right to privacy outweighs the public's interest in participating in those hearings. The Family Code also provides that under certain exceptions, the court may also close hearings for children above the age of 14 when there are special intervening circumstances. All of those factors apply to the remaining hearings today, and so the court will discontinue the live stream on YouTube. I want to thank everybody who has been watching today's proceedings. It's important that our citizens keep abreast of what is going on in their governmental institutions. This includes the courts. I also hope everybody had a safe and happy St. Patrick's Day. I hope you have a great rest of your weekend. And